From the campus of the University of Nebraska at Omaha. Consider This, a program of issues and information behind today's news.
At the Supreme Court today, an historic upheaval. In a sweeping ruling that overturned a half a century of precedents, 5 justices ended the right of American women to choose abortion under the Constitution. The court upheld Mississippi's ban on abortions after 15 weeks by a 6-3 vote, and 5 of those justices went even farther, voting to overturn Roe v. Wade itself.
Hi everyone, I'm Kathy Wyatt. Welcome to the 25th season and this week's edition of Consider This. Our topic, an end to federal abortion rights. Joining us to talk more about it is Kendra Vershey. Kendra is a professor of law at Creighton University. Thank you so much for being here and welcome.
My pleasure.
I want to start by asking, when we talk about abortion rights, what are we really talking about?
Well, as the Supreme Court was focused on in the Dobbs decision and initially in the Roe versus Wade decision, actually a little before that when the court found sort of the precedent-setting ruling in Griswold versus Connecticut, it's really about privacy rights. So the Constitution doesn't say the word abortion, nor does the Constitution say the word privacy. The court in Griswold versus Connecticut, which was a case that was decided a few years before Roe versus Wade, the court basically looked at the Constitution and the Bill of Rights, particularly the first 10 amendments to the Constitution, as a holistic document and said, sort of in the shadows of these rights is the idea that privacy is protected by the Constitution. And that privacy right set the basis for determining that married couples in Griswold versus Connecticut had a right to seek contraception without state interference. That was the basis for Roe versus Wade, and really kind of very similar decision. The reasoning from Griswold with the contraception access was carried over into Roe versus Wade, having to do with medical decision making, that women could have that privacy right that's protected to make decisions with their doctors about what's right for their bodies.
Okay, pro-choice.
Correct.
Right. So let's talk about the other side, right? So pro-life, anti-abortion.
Mm-hmm. So the Constitution only allows states to interfere with the rights of private citizens to the extent that the state thinks that there's some interest in doing so. And so the state has the power, certainly like in the criminal law context, to say that we're not allowed to punch each other or we're not allowed to steal each other's cars. The Constitution recognizes a right of states to exercise what are called police powers, which help the states set regulations for health and safety. So the idea is that there's this tension between the body of the Constitution that recognizes the right of the state to regulate citizens in the state for health and safety reasons versus the rights of individuals to live free in our nation that believes in these freedoms. And how we define those freedoms is where the rubber hits the road.
Okay. I want you to talk a little bit about the Supreme Court and the role that it plays in determining what is protected by the Constitution.
So this is really where at the heart of the Dobbs decision and a lot of decisions that the court has made in probably the last 40 or 50 years. The court has very clearly stated that the amendments to the Constitution, while they don't say certain words, there may be rights that are recognized by the court because, for example, the 14th Amendment says that we have a right to liberty. What's that mean, right? The question is, what exactly are we protecting for citizens and states, and how are we restricting states from invading those liberty interests? So the court created a paradigm in which it looked at liberty interests from a couple different lenses. We can recognize a liberty interest because it's been around for a long time. We all recognize it as something that, that the states have allowed for a long time, and therefore we must not be worried that that's going to be a harmful liberty interest, and we can go ahead and continue to allow that liberty interest, or sort of recognize it through the Constitution and through the court's decision-making power. There's another way to look at liberty interest, which is maybe these aren't interests that we have recognized since the beginning of the early days of the United States, but maybe there are interests that are important to our sort of health and happiness and fulfilled lives as American citizens. As the court has become more conservative, the court has leaned more heavily on the version of recognizing liberty rights that really are only looking at it through the lens of what's traditional. What have we always recognized as liberty rights? The problem with that is we know that we weren't very good about recognizing liberty rights for a lot of people in the United States for a long time. So if you were a person of color or a woman, you weren't granted the same liberty rights as landowning white men. So looking at these restrictions, if the state says, well, we want to restrict something, we want to restrict the liberty of individuals, if the court says you can do that unless this is a liberty interest that we've recognized for a really long time, what ends up happening is we cut back on liberties that are more recently recognized as important to all American citizens.
Okay.
So there's a lot there.
No, but a good segue then into, I want to go back to 1973. We
Yep.
are going to put up a photograph of the Supreme Court justices. And as we're doing that, Kendra, I want you to talk about who are these people a little more, and you've alluded to it, but a little more about the case that was before the court, and then we'll move from there.
So, you know, you can see from the graphic that it was obviously all men. It wasn't entirely white men. Justice Marshall was on the court at the time, so we had at least one African-American jurist. But you know, this obviously looks like, if we were just sort of glancing at this picture without any background, we'd say this looks like a very conservative group of people. But this is the group of people that recognize the right to privacy extended to the abortion right. The opinion was written by Justice Blackmun, who worked very hard. It's a very long opinion, Roe v. Wade, with a lot of analysis of the question of what parts of the Constitution would support this idea that someone's privacy right would allow them the access to an abortion. And Justice Blackmun's majority opinion at the time looked at all these different areas of the Constitution where we kind of know that there's something about privacy lurking in what they called the penumbras, like the shadows of those amendments. And so the court, even though it was a court that really didn't have, we don't know that they had really any personal interest in recognizing a woman's right to choose an abortion, the court recognized the importance of medical decision-making and the privacy that someone would want the state to stay out of when it comes to these intimate decisions like contraception and abortion. So the court in Roe versus Wade said that the privacy right is in multiple parts of the Bill of Rights. You can find this idea of privacy in the First Amendment, right? We say that you have the right to speak your mind, and there's a certain sense of privacy that's recognized in that right, that you can exercise your ability to sort of be a part of society and express yourself in whatever way you choose. There's a privacy interest there. Also in the Fifth Amendment, the Ninth Amendment, and the 14th Amendment. 14th Amendment was the part of the Constitution that mentions specifically this liberty interest. And that's really what the court looked to in Dobbs when rolling back Roe.
I want to put up a couple of photographs for the viewers, and as we do that, I just want you to talk a little bit about what we're seeing, right, and what was going on at that time.
Mm-hmm. So, this is not a new issue. The idea that women have been advocating for a constitutional right, or asking the court, really properly stated, to recognize their constitutional right. So the idea is the Constitution has protected rights since the beginning of American history as we were a formal nation. organized under the Constitution, but sometimes the court was slow to catch up, right? The idea is that those rights have been there, but the court didn't necessarily see them there until we realized that, maybe we shouldn't be treating women as second-class citizens, or maybe we shouldn't be treating people of color as second-class citizens. So the protests and the sort of focus that we put on abortion rights, both from the perspective of people who are opposed to abortion rights and people who are in favor of abortion rights, was really the culmination of this understanding that we live in a society where women are active participants, and that creates challenges for family planning and financial burdens, and we need to recognize that the autonomy and independence from the pro-choice perspective, and then the pro-life perspective would be the rights of the fetus, that there's a tension there. And the court really, in Roe v. Wade, said we understand that the state shouldn't, that each individual state shouldn't have the power to control women's decision making when it comes to medical care.
Okay. Then we get to current day. We're going to put up another photograph for our viewers. This would be the current Supreme Court justices. So tell us a little bit about them, Kendra, and the case that would have been in front.
So obviously a much more diverse court, at least in terms of race and sex, but not a more progressive court. Certainly, we've got a conservative court that has at least 6 justices who are ideologically opposed to the abortion right, in that they said in the majority opinion that the court needs to recognize the state interest in protecting unborn life, in which case you've got 6 justices saying that there is sort of a government interest in fetuses before they've taken their first breath, that the government has an interest in controlling and protecting that pre-born life. With that breakdown of 6 ideological justices in favor of restricting, or in favor of allowing states to restrict that liberty interest, and 3 justices who are opposed, really it was not a close decision. It was actually, even though Justice Roberts didn't agree with the reasoning of the court, there's a comfortable margin in favor of overturning Roe v. Wade here.
All right, so if we go back, I want to bring up Ruth Bader Ginsburg now. When she passed away, there was serious concern, deep concern, in terms of what was going to happen moving forward. And as we put her photo up, I want you to talk a little bit about that, especially as it pertains to this particular issue.
Justice Ginsburg, this is a complicated history with Justice Ginsburg, because Justice Ginsburg was somewhat famous for actually being critical of the reasoning in Roe v. Wade. And the reason she was, not the decision, not the judgment, meaning recognizing the rights of women to make that decision, the decision to have an abortion, but more so, and she thought the reasoning was vulnerable. She said that this idea of the penumbras and kind of recognizing this privacy right was a less direct path to recognizing the rights of women to choose abortion than an equal protection clause analysis that would have been harder for the court to overturn. Now, she wasn't particularly worried, at least while she was on the court, that Roe v. Wade would be overturned, because she said she knew that the court believed very, very strongly in the concept of stare decisis, which is this idea that the court will not overturn precedent, that the court stands by for former decisions, and that concept is that once the court's made a determination, it rarely will overturn that decision. So once it's settled, once it's decided, it's settled law. And Justice Ginsburg said this court believes in stare decisis, Roe is settled law. She did have concern about the cases coming in and whittling away certain rights or certain types, certain procedures, shortening the window of when someone could seek an abortion. But she was not concerned, while she was on the court, that the right would be overturned entirely. In other words, she didn't think Roe would have been overturned. But I remember the moment when she died, or when we heard that she died, and thinking, that's it, Roe's gone. Because she was the last, I mean, it would have been 5-4, and I suspect Justice Roberts would have sided with the liberal justices that perhaps he would have been okay with a whittling, another sort of step back from Roe, but he even now did not agree with overturning Roe. But it didn't matter because the majority was 5-4 even without him.
So I want to ask you about this whole notion of legal principle driving decisions versus that thought that maybe that's no longer the case, and maybe it is political belief that is kind of seeping in
Right.
and taking over here. Thoughts on that? When we look back at 73 and then we come to where we are today and listen to what you're saying, I would imagine that you have an opinion about that.
Yeah, so the thing is, and this is, Supreme Court justices are human, right? We expect that they're going to have opinions about things, and that's okay. It's fully the paradigm in which we've been working since the beginning of the court. The stare decisis system was set up in a way to sort of avoid the vagaries of the opinions of individuals from changing the course of our laws, right? And so the idea is that the justices make learned, thoughtful decisions. They make expansions or retractions in the law on the basis of legal principle, and that those decisions that the court makes will be the basis on which we stand, and we move forward from there. And we don't tear apart that foundation beneath what the justices have built. And so even if you have justices that are ideologically different than the justices that came before, the idea is that the only thing that would change the precedent that was promulgated, that was announced by the court, would be if there's something extremely problematic with say the court got something terribly wrong in the past. And the example that the court actually even relies on in Dobbs is Plessy versus Ferguson, was a decision the court made in the late 1800s, I think 1899, and that was the separate but equal case. So that was where the Supreme Court said segregation on the basis of race is permissible legally. Brown versus Board of Education in the 1950s came along and said, we got that wrong. That is not constitutionally valid reasoning. And so the Dobbs court looked to that and said, this has happened before. We have changed our precedent in the past. And this giving Plessy versus Ferguson the giving that example. The problem is that Plessy was wrongly decided because it improperly restricted the rights of individuals on the basis of race. And the court said, we don't do that. That's not right in a free country. Now in Dobbs, the court has said the restriction of rights after they were once granted is permissible. So I think these two determinations, one overturning Plessy and now overturning Roe, are on very different footing. And that the comparison to Plessy is an improper one in my mind.
You have people now who are concerned that because this has happened, that other things are going to be coming down, other decisions, other overturning.
Sure. Yeah.
One that we're hearing quite a bit about is this whole idea of same-sex marriage.
Right.
So talk to our viewers a little bit, Kendra, about this whole idea of privacy and then as it pertains to same-sex marriage.
So here's where the court was even more sort of complicated in its reasoning, and I think muddied the waters, even though the court tried very hard in the majority opinion to say, well, we're not going to delve into these other areas. Justice Thomas said, oh, but we are if I have my way. So when the privacy right was so criticized, really was sort of wiped away by the court in Dobbs with respect to abortion, it makes you wonder about all other cases that are decided on the basis of the privacy right. Contraception, right? As I mentioned earlier, Griswold versus Connecticut was this early case that was where the court came up with the penumbras and the privacy right kind of in the shadows of the First, Fifth, Ninth, and 14th Amendments. And so that's in question. If the privacy right is invalid with respect to abortion, why would it be invalid in terms of protecting people's rights to contraception? With respect to same-sex marriage, that one worries me a little bit less in terms of the court's sort of willingness to invade that right, because the Supreme Court in 2015, when Obergefell was decided, actually used a more broad reasoning basis than just privacy to recognize same-sex marriage. So there are other, it's equal protection and other parts of the due process clause that the court relied on. But Justice Thomas said he believes that Obergefell was wrongly decided and should be revisited. So any of the cases that use that reasoning of privacy that comes from Griswold and Roe, we have a potential problem. And so I wouldn't be surprised if we start seeing states testing whether the contraception rights can be, whether the state can say you can't have access to certain kinds of contraception now. Same-sex marriage, I think, will be a different battle because the legal precedent there is a little bit different. But if Justice Thomas is more convincing to his colleagues on the court, we may just see that also come into question.
Substantive due process. What does that mean?
Okay.
And how does it apply here?
So the due process clause of the 14th Amendment has two parts. One, the idea of due process the court has recognized is what you would traditionally think of as process. Like you get fair process. The police can't come into your house and just take a lamp and say, that's ours now and you can't do anything about it. You have a judicial process that you're allowed to vindicate your rights. That's protected in the 14th Amendment, and the 14th Amendment also applies to states. So the states can't say, well, the 14th Amendment isn't about us. We get to do whatever we want. Everyone in the United States has the protection of due process. So the procedural side is clearer. But then the court said that there's this concept of a substantive due process right that protects our fundamental liberties. And this is where the liberty interest comes from in the 14th Amendment, that that people are owed due process in their liberties. The state can't come take things from them or throw them in jail for no reason with no process, but also that those liberties are protected. That even if you're not being thrown in jail, you have some rights to be free in America. And so the substantive due process part of the due process clause really protects these fundamental rights that we have. The right to marriage is one of them. The right to, domestic travel. The court has recognized some fundamental rights that we have that really can't be stripped unless there's a really, really good reason to do so.
Okay, we have less than 5 minutes remaining, and I do want to get your thoughts on this whole notion of where do we go from here?
Yeah.
Right, and as we do that, we'll put up another graphic for our viewers, but I want you to talk a little bit about, as we sit here today, how are we moving forward?
Okay, so Dobbs said that Roe v. Wade is no longer precedent, cannot be relied on to advance the rights of the individual who's seeking an abortion if the state in which she lives bans it. So it's still legal in states that haven't banned abortion. And in fact, there are already battles brewing in states where their trigger laws happen. So when Dobbs was decided, some states had laws that said from this moment forward, abortion's no longer lawful in the state. There's Louisiana and Utah, there are already legal battles, and two judges, one in Louisiana and one in Utah, stayed the trigger laws and said that can't take effect yet. We don't know what the legality of them is. So there's that, looking forward, that we're going to have state level battles about what abortion laws are lawful. So I could see, for example, a state banning abortion in every instance, no exceptions for the life or health of the pregnant woman, no exceptions for rape or incest, and someone has an ectopic pregnancy and her life is in danger, seeks to challenge that law, and it goes up to the Supreme Court. The Supreme Court says, actually, that's not constitutional. A state can't ban it to that extreme. So it's possible the Supreme Court could say there need to be exceptions for health and life. It's also possible the court could say, we're not answering these questions anymore. This is a state decision. It's not our call. So really what's happened is the Supreme Court has said the federal government is no longer in this in terms of a constitutional right recognition. This is what's the battlegrounds are in the states now. And so it's a more political question. Who you elect from your state is going to be making the decision on whether there should be an exception for the health and life of a person who's pregnant. And if the state says you've got an ectopic pregnancy and it's going to kill you and the embryo, it is what it is, right? That's what the state said, and the court now has said we won't hear an appeal.
So this is going to be tough. We have 15, 30 seconds. I want to hear your final thoughts on this whole thing. Talk to our viewers and give your final thoughts.
So this is the beginning of a new battle, and we are looking at a new legal landscape where we have to fight our fights at the political level, no matter what side you're on. So the legislatures and Congress are what's going to matter when it comes to whether we recognize abortion rights in America.
Professor Kendra Forshey here today talking about an end to federal abortion rights. I want to put up some information if viewers want to know more about this. I also want to thank you for sharing your time and expertise. SupremeCourt.gov and SCOTUSblog.com. Those are just a few places. Again, Professor, thank you so much for being here today.
My pleasure.
We wish you very well moving forward. Yeah. And thanks to all of you for watching. We'll see you next week.
Consider This is an issues and information program produced by UNO Television. More information and program archives can be found at nebraskapublicmedia.org/considerthis. If you'd like to share your comments about this program, call UNO Television at 402-554-2516 during regular business hours, or send an email to cwyatt@unomaha.edu.